Hello, my name is Donnell Ginyard. This channel is called Thedefendant. I'm the creator of this channel. For the record, I am a paralegal. At this time, I want to give a message to the people that run the following YouTube stations. 1. End of sentence. 2. BMG upper class. 3. Fed it. And 4. King Say So Reacts To. In short, after reviewing you guys' content on the Caswell Sr., aka Casanova case, I have reached a conclusion that you guys' content on this case is violating Mr. Sr.'s right to the presumption of innocence. To be sure, after reviewing you guys' content, it is clear that neither of you guys or y'all followers could be a juror in Mr. Sr.'s case. Another way put, neither of you guys or any one of your followers could provide Mr. Sr. with a fair trial. Also, I would like to say that after watching you guys' channel, it is clear that you guys have absolutely no respect for the rights of the accused. Do you know that the presumption of innocence is a fundamental idea in trial law that helps our legal system to remain fair? The presumption of innocence means that anyone accused of a crime is assumed to be innocent until they have been proven guilty. True story. After reviewing you guys' channel, it looked like all of you have assumed that Mr. Sr. is guilty. I bet that all of you guys also believe that everyone who is accused of a crime is guilty too. In closing, today I'm fighting for accused person's right to the presumption of innocence. And since we are on the record, I'm going to give you my reasons for why I feel the presumption of innocence is considered good for us and worth fighting to maintain. First, it is good because people lie, people give false evidence, and people do all things in between. They may do this in the course of attempting to prove guilt or innocence. This is a fact of human nature, and this is why a person charged with an offense is presumed innocent, not a saint. Second, it is good because the presumption of innocence presumes the best of us and not the worst. It places humans on a high plane and thereby facilitates, where appropriate, a plea of guilty. This is important in the administration of justice and with us feeling right with the system of justice. In sum, I believe that my reasons for fighting for the presumption of innocence are valid, and if you believe the same thing that I do, you guys should agree that YouTube channels, the media, should have a major role in protecting this right. At the end of the day, I understand that you guys' media channels are driven by the desire to reach and keep larger audiences and are pressured by the competition of new communication channels such as social networks and video sharing platforms. However, you guys can't be tempted to ignore the fundamental rights of suspects and accused persons and publish information that would affect the presumption of their innocence. Do you guys understand that the potential impact of a violation of the presumption of innocence is not limited to those directly involved in the proceedings? Inappropriate disclosure of information can affect the accused person's life in many ways and his or her family. Do you understand that you guys' content can cause someone to lose their job, become isolated from the community and family, and for their reputation to be damaged in society? True story. I really hope that Mr. Sr. gets acquitted and he and his family sue you and obtain compensation. Okay, it's time for me to go. Thanks to everybody for watching this video. If you wish to learn more about the presumption of innocence, please stay tuned. Also, if you want to hear one of Casanova's classic videos and that's really relevant to this time, please stay tuned.
But we begin with a brief discussion about the origins of presumption of innocence, which is considered to be a very important part of our criminal justice system. And our criminal justice system was borrowed from the English common law. So it might surprise you to find out that the presumption of innocence is not found and was not originally found in English common law. It was borrowed from the French Roman law and adopted into English common law near the end of the 12th century. And was adopted by reform-minded jurists who were trying to move away from the proof practice of that era and it involved what was called a test or an ordeal of proof. Ordeal of proof was like a medieval way of proving guilt or innocence. It required you to subject yourself to these tests. For example, there was a boiling hot water test where an accused was required to stick their hand into boiling water and to retrieve a stone. And after the stone was retrieved, the injured hand was wrapped, and after 3 days, they would unwrap the hand to see if it was healing or blistering. If it was blistering, you were guilty. And if it was healing, you were innocent. So that is how people proved their innocence under English common law in the 12th century. So these reform-minded jurists decided, we want to move away from that. We want to incorporate Roman law, which involved a process of proof that didn't include these types of torturous, horrible practices. But these practices had been embraced by the people, by the church, by the rulers, and they knew that it would be difficult, it wouldn't be easy to make people switch, to move away from these sort of pagan rituals and practices. And so they came up with a wonderful way to come up with a compelling argument to move towards this Roman law. They looked at some of the principles that were contained in Roman law, including the presumption of innocence, and said that this was not just a product of community norms, like most common law, but it really came from God. These were divine principles found in the Bible. And they said the presumption of innocence came from the book of Genesis. And it began when God said to Adam, after he found out he had eaten from the tree of life, and he confronted him. He asked him, even though he's omnipotent, what did you do? And Adam was given an opportunity to explain himself. And so these reform-minded jurists said this presumption of innocence that God gave to Adam is something that everyone, all people, should be entitled to. And so they said the Roman law and these principles, including the presumption of innocence, was divine law. And over time, they managed to convince people, including the church and rulers, that not only did this apply to common people, but it applied to rulers and powerful people. Everyone had to submit to this concept of presumption of innocence. So if you flash forward a couple centuries, we end up having this same presumption, which transferred from Europe to America through the colonies, and ultimately it was recognized as being an integral part of our system in 1894 in a case called Coffin v. U.S., where we embraced this idea of presumption of innocence being an integral part of the Anglo-American jurisprudence.
The presumption of innocence, the defendant is presumed innocent. That's the starting point. He's presumed innocent of these charges, and this presumption remains with him throughout the course of the trial, the presentation of the evidence, throughout the course of your deliberations, until and unless the state has proved its case beyond a reasonable doubt. The defendant does not have to prove his innocence. We talked about this in jury selection. We talked about the starting point. The defendant doesn't have to try to catch up. He starts at the presumption of innocence.
The presumption of innocence is something that exists here in our courts, in our state, and in our country. It is not something you can see or touch, but it is something you can feel. It's like a blanket that wraps around you when you're charged with a crime. And it doesn't come off until the end of your trial if the state proves the charges against you beyond a reasonable doubt. Now, the purpose of the presumption of innocence is to protect you from being charged unfairly or unfairly punished for something that the state cannot prove that you did.
Morning. This proceeding is being conducted by video and telephone. This is the matter of the United States versus Caswell Sr., case number 20-CR-626. Starting with the attorney for the government, can you please note your appearance for the record?
Good morning, Your Honor. AUSA David Felton for the government, and AUSA Shiva Logaraja is on the line as well.
So please the court, my name is James Koussouris, Koussouros. I appear this morning on behalf of Caswell Sr.
Has left the conference.
So please the court, we fully recognize, as we have in our submissions, the seriousness of these offenses. We have recognized that Mr. Sr. had a prior robbery for which he served 6 years, a robbery that occurred some 14 years ago. And however, we have therefore in turn offered a very serious and significant bond in this case. We did not approach the court for over a month with a bond with just some co-signers. We knew that a significant bond would be appropriate in this case, and so we have compiled a $2.5 million bond secured by 5 properties with equity in excess of $1 million and co-signed by 13 responsible sureties, most of whom are, or all of whom are on the phone with us today. This bond would be accompanied by the strictest of pretrial conditions, including electronic monitoring, home confinement, surrender of all travel documents, drug testing, and strict pretrial supervision. And so when the government asserts that we have done little to assure the safety of the community, at least with respect to cabining,
has joined the conference,
to confining Mr. Senior in his home in New Jersey with his wife and his daughter under conditions as strict as this, along with the property and sureties, which essentially come close to fully collateralizing this bond, I submit to the court respectfully that we have submitted much to assure the court as to the safety of the community. Your Honor, your question is the question that, quite frankly, I've had in this case for some time, and that is, for example, for the 924C conspiracy. There is no evidence, in my view, put forward by the government sufficient to assuage this court or convince this court as to the strength of that part of the case. The government has put forward photographs of weapons. Mr. Senior is not in those photographs. He's not possessing those photographs. And as we stated in our reply, just as an example, we say the government is presenting the court with photographs of weapons that are promotional photographs. We may not like them, many may not like them, but that's what they are. And when the government responded to our motion, what did they do? They did exactly that, Your Honor. They posted or submitted a photograph of a weapon that had a caption of "Gripped Up." Well, "Gripped Up" is a rap song that was, in fact, recorded a few days before that. That's what that photograph is. That Mr. Luster would go and talk to Mr. Reed or anybody else and say things about Mr. Senior for whatever reason he may want to, that's not evidence that Mr. Senior was ever in possession of a weapon or ever in possession of a weapon in conjunction with the charges filed. Let's talk about what's real. What's real is a witness statement that I received from the government a few days ago. It's redacted. I have no interest in
has joined the conference.
I have no interest in disclosing names or anything like that, but this is a witness who is proffering, and he is a cooperating witness with the government. And what does he say? He says that he knows Mr. Senior since 2015. Now, I'm assuming this was partially a Brady submission. He knows Mr. Senior since 2015. He advises that he never sold drugs with Kaz, nor did he ever know or hear about Kaz being involved in the sale of illegal narcotics. He does talk about credit card scams, but that's not what we're talking about now related to danger. And he also advised that he never observed Mr. Senior carrying a firearm. Now that's real evidence.
I just want to interrupt you. This witness that you're relying on implicates Mr. Senior in credit card fraud?
He talks about credit card scams. But when it comes to weapons, now this is a fellow that knows him since 2015. And he's never seen Mr. Senior in possession of a weapon, notwithstanding the blathering of another defendant to yet another defendant that he always has a weapon. Mr. Senior's appearances are very public. They're videotaped. He's never seen with a weapon. I haven't seen a photograph with a weapon in his possession. I have a letter from the production company that produces many of the photographs and many of the videos that Mr. Senior is involved in. And they specifically state that all of the weapons are props. The name of the company is Street.
Raphael Cameron.
So left the conference.
So here's a witness that the government, I would suppose, believes, because this is a cooperating witness, who, for the last 5 years, has not seen Mr. Senior with a weapon, has not seen him committing any robberies, has not seen or known him to be involved in narcotics. So you've got photos of weapons, and you've got this fella visiting Mr. Reed, telling Mr. Reed that Mr. Senior mistakenly fired a gun at a poker game. Well, let's just think about that. This was a wired room. The government installed a listening device. The government makes clear that, in fact, Mr. Senior also visited Mr. Reed. Where are conversations where Mr. Senior is talking about such things? I mean, I certainly don't think it's something to brag about, but you would think, given the context and the landscape the government has painted here, that the first thing Mr. Senior would be telling Mr. Reed is, you're not going to believe this, I was playing poker and fired a gun. So what the government proposes in terms of the weapons charges are photographs that don't have Mr. Senior in them, photographs for which they can never prove they were real weapons, photographs that are clearly, it's really undisputed, are promotional photographs for a rap song that was recorded a few days before, and then statements by somebody else to yet somebody else about things about Mr. Senior. This is a multi-year investigation, Your Honor. I was informed that we're getting 4 terabytes of discovery as the initial provision. Where are there any photographs of such things? The government wants to attribute the violent acts of others to Mr. Senior. A jury will decide that at some point thereafter. But there still are no claims that I can see as we sit here today since 2013, when Mr. Senior was released from prison, where, one would suppose, if you take the government at their word, he gets out of prison in 2013 and begins his, I suppose, ascension to the top. Well, where is the activity in 13, 14, 15, and 16? Where is there any violent activity attributed to Mr. Senior? There is none. And I respectfully submit that there is none because there was none. The government points to, these interviews. I've seen them all. And they're easy for Your Honor to see. And they are interviews about the past. They're interviews about his childhood. They are interviews about what happened in his life up to the age of 20 when he got arrested for that last robbery. In our submission, we have provided to the court a February 2019 interview that was conducted by, I think it's called Montreality. Now, Judge, I don't know. My understanding was that all you needed to do was click on the image and it would come up. It's on YouTube. Your Honor, how does the government square those words? This interview is not posturing. And very interestingly, he doesn't hide his otherwise public image. He's sitting there with a diamond necklace and his 2X brand, and it's all shiny, and he's dressed nicely as he sits and tells people that you don't get paid for being a gangster. You can't get paid. The only payment you get is death or jail, guaranteed. There's no gangsters getting rich and chubby moved to Miami. You don't go to heaven. It's a lie. It don't matter what the preacher says when you're getting buried. Oh, he was a good man. They shot him for no reason. You're going to hell. You're doomed. You're doomed 2 times. You're finished. If you ask me, that's the government's summation in this case. And Caswell Sr. is providing it in February of 2018 to anybody that'll listen. And if you go through the balance of the interview, he talks about his childhood. He talks about how on the streets they don't tell you that you're going to lose your family and they're going to lose you. They try to glamorize it. So I suppose at the end of the day, Your Honor, and there's been much litigation about the admissibility of rap songs, the admissibility of lyrics, the admissibility of photographs, and they do need to be tied to the activity. But in terms of a jury deciding at some point in the very, very distant future which is the real Caswell Sr. relative to these charges, I submit to you most respectfully that what we have provided to you are two sides to the story. So the law provides that it's only a limited number of individuals that should be detained pre-trial. And we also do cite for the court, and you know, I have to say the government's response to this, it was unfortunate, because the pandemic has created a situation that should be considered by the court in conjunction with the other 3142 factors. We're not suggesting that we open the doors to the prison so people can prepare their defense. There's no question that everybody who's incarcerated right now is living through more of a hell than we on the outside are living through, as at least we're able to put our masks on and move about somewhat freely. I cannot visit Mr. Senior. I haven't been to the MDC since October. I haven't been to the MCC since March. The notion that a defendant can prepare a defense and effectively review discovery with counsel with 1 hour video meetings with not very good audio, or 1 hour meetings at the jail when they're ever to be resumed, which they are not right now, is foolhardy. It's not true. And my only point is that this is a factor that should be considered in conjunction with the other factors. And when a defendant such as Mr. Senior puts forward valid and viable arguments as to the strength of the evidence, and then puts forward a bond in the amount of $2.5 million, almost fully secured, with very strict pretrial conditions, I submit to this court respectfully that the court should consider also his ability to prepare a defense, his ability to advocate for a speedy trial if he does find himself in a different situation than his co-defendants because he was able to prepare. The bottom line is we should all strive to give every defendant in this country the ability to prepare a defense effectively. And my question in my response to the government is rhetorical, but I would ask the government to just think about it. If we did turn the tables, would the government agree that it could prepare its prosecution in this case if it had access to its agents, access to its witnesses for an hour at a time to review, 5, 6, 7 terabytes of discovery for the first time? Of course not. They could never be ready, and they'd be singing a different tune if it were the government in that position. So all I'm saying is that is something that should be considered. With respect to flight risk, of course the government is not pushing that too hard. And here again, the government shouldn't be pushing at all, in my respectful opinion. I understand the exposure. I understand the seriousness of the offense. That's why you have the type of bond you have before you. But honestly, Judge, it is the gravity of the offense. It is the exposure in this case, when considered with the fact that Mr. Senior voluntarily surrendered, that puts him way over the top in terms of not being a flight risk. Because if anybody was even remotely a flight risk, this is when you run. And, the government's assertion as to his conduct upon finding out that he was being sought, well, let me say this. The word was out that Mr. Senior was being sought. The press reports spoke of violence by many members of this gang. You cannot blame a guy, and respectfully, Judge, I'm speaking rhetorically, one cannot blame an individual for figuring out a way to surrender without being shot. And I'm not saying that they were gunning for him, but obviously it's a very tense situation when the government is seeking somebody who is involved in alleged violence. What did he do? He called me immediately, interviewed me, hired me. These were no rounds. These were no rounds of negotiations. I spoke to the agent who was at his house trying to speak to his wife. He was courteous enough to conference me in with the government. This was the night before he surrendered. I asked for a few days so he could get his affairs in order. They said no. We said okay. So he's in Atlanta very far away from New York, much closer to anywhere he wanted to run. So what did he do? He fled to the jurisdiction that he was wanted in, and then walked into a precinct.
Mr. Caceres, I don't mean to cut you off, but I take your point on this, and frankly, I think risk of flight is the least of our problems here.
Well, that was kind of my point, and I'm glad we got there. Judge, I do understand any concerns for danger here, but I think that your point is most valid. I do think that there is really a question as to whether there is sufficient evidence here as to danger, the way there is sufficient evidence, certainly with respect to the 924C. With respect to the narcotics trafficking, I mean, let's be clear. All you have are some photographs of Mr. Senior in front of bags of marijuana, a drug soon to be legal in the United States. And I'm not saying it's legal now. But my point is that government has not said a word to you about the actual basis for the B1A. There is no evidence of trafficking in anything else but marijuana at all. And their own witness has said that he's never seen Mr. Senior involved in narcotics. There's nothing, I've heard nothing, not a post, not a text, not a photo, no evidence whatsoever of him trafficking in controlled substances. And so I do think respectfully that even those charges are going to be difficult to prove. Your Honor, you've read our submissions. I know that I've gone on for some time here. The other examples by the government again are this one co-defendant talking to somebody else about him in the same wired room that Mr. Senior would have been overheard saying whatever he's saying. And with respect to the Florida situation, Judge, it's easy to just blame somebody for being at a particular place. But, what happened here was that, Mr. Senior's down there with his family. He's celebrating his birthday. He's taking photographs. He's taking celebratory photographs. He is not armed. He is not in any way conducting himself in a violent manner. Now, I have to think that this whole episode had to be videotaped. This is a strip club. I have to think that they have, tapes of the outside. I welcome, seeing them. But he is not telling anybody to do anything. And while the text messages in the complaint do mention him, it's very clear that he is not telling anybody to do anything. Interestingly, somebody, according to the complaint, after words are spoken, reaches for their hip, that would be self-defense. I mean, it would be possession of a weapon, but that would be self-defense. It's very clear Caswell Sr. is not armed, and he's not down there looking for trouble. So, again, and he's not charged. Now, if you look at the government's recitation here, if he's the big boss and he's directing violence, well, then he would have been charged. There is no evidence sufficient to charge him with that. And finally, with respect to the diner incident, I don't see how you could possibly say that this is a gang-related incident. He is in a diner, sitting across from a woman half his size. She's videotaping. She asks her to stop. He does not direct anybody to do anything to her. He self-surrenders in that case. We attach the video that we have for the court's review. He surrenders in that case. He's offered a misdemeanor and refuses because he didn't do anything. It's a fellow with a robbery conviction that did 6 or 7 years, Judge. You get offered a misdemeanor and a CD in state court, and you don't have to keep going back to court, especially when you have a prior record. It doesn't add to your predicate status or anything like that, and he's certainly not thinking about Chapter 4 criminal history points. He refuses a misdemeanor because he didn't do anything. So, again, the government is attributing somebody else's conduct to Mr. Senior. So the simple question is this, Judge. Aside from the innuendo of he's some big boss directing people to do things. The government has not come forward and put a gun in my client's hand. The government has not come forward and giving you any evidence of him directing anybody to commit any kind of violent act. The government has not come forward and say, Judge, we know that he sold cocaine or heroin on a particular date. We searched his house and found money. There is nothing except inferences from what other people have said and photographs that he has posted to support these charges. And again, that doesn't mean I'm asking you to simply release him on a $50,000 bond with a signature. What I am respectfully submitting to you is that Mr. Senior can be released on a $2.5 million bond with immensely strict pretrial supervision that will keep him in his home. Everybody that he's accused of ruling over, so to speak, is incarcerated. And that really should assuage the court's concerns as to safety. I want to also just point this out to you, Judge. There's also this argument by the government that this same fella is overheard stating that Mr. Senior asked him for protection. Well, here again, we don't have Mr. Senior doing that, and I know the government has tens of thousands, if not hundreds of thousands of texts. Where is there a text from Mr. Senior saying, I need protection? But moreover, if he's such a danger to the community, why does he need protection? I want to tell you, Judge, there was a short while ago that Mr. Senior and his entourage were entering the Barclays Arena. They were attacked and shot at, and there's a video of it. So far from being protected by his entourage of armed individuals, they ran like chickens, just turned around and ran out of the place while they're being chased and being shot at. So far from being a man who needs protection, there was no protection. And aside from one guy bragging to another guy because he wants to brag to another guy that he's with Caswell Senior, a famous rap artist, there is no evidence that he ever asked for protection, that he ever wanted protection, or anything of the like. These are words of somebody else. Your Honor, we have given the court some of the finances, Mr. Senior. We have addressed the situation which we would ask Your Honor to consider.
The conference.
Mr. Senior is more than happy to provide a full financial statement. His lack of doing so is on me. He didn't have specifics. I told him we would provide specifics. We've given the court his 2019 adjusted income to the penny, what he has in his bank accounts. We've explained the OnlyFans thing. He made, I think, $29,000, not $1 million, and that can be verified. Your Honor, this is a huge bond with very strict conditions. All of the sureties are available to be interviewed. We have all of their documentation to support their ownership of the properties, the equity in the properties, the outstanding balances, and the value of the properties. We have W-2s, tax returns, and everything else. And the fact that Mr. Senior is not a millionaire who can post all of this on his own, again, most respectfully to the government, that's not fair. We post bonds all the time. In fact, most of the time, it is family members and friends over whom there is moral suasion by a defendant that they would not ruin the lives of 10, 20, 30, 40 men, women, and children by fleeing. And Mr. Senior has made it very clear in his conduct that irrespective of what he is facing, he faces justice and he surrenders to do so. So I have been long-winded. I really appreciate your patience, and I would respectfully submit that a bond in this case should be granted.
Thank you, Mr. Kasouris.
Your Honor, if I very briefly, I just want to make one thing clear. I was not saying that any actions were taken in self-defense in Florida. My point was that when somebody reaches for a gun, if Mr. Senior was armed, then you would expect that he would have taken it out. My point is that he wasn't armed, and that was the only reason I made a reference to self-defense. With respect to Luster and Reed, Judge, even though they may not think anybody's listening, Luster may have every reason to be bragging about being around Mr. Senior and saying things to Mr. Reed. It does not make those statements reliable, especially when the government has absolutely nothing to corroborate, Mr. Senior being in actual possession of weapons other than photographs.
Thank you, Mr. Kousouris. All right. I have considered the extensive written submissions I alluded to earlier, the nature of the charges, the information reported by pretrial services, and counsel's rather extensive arguments and proffers in this hearing. And I have to say, defense counsel has proffered what is, by any standard, a formidable bail package, and particularly coupled with this defendant's relatively high profile in the community, and the fact that he did surrender upon within a short time frame after learning he was being sought by the authorities. I cannot find that there are not conditions available that would assure the defendant's reappearance in court. However, danger to the community is a different story. Frankly, the defendant's role in this organization is a little bit difficult for the court to fully understand, and I think I take some of Mr. Kousouris' arguments. For example, posting photographs, unconnected to time or place. We could all post photographs of unicorns, and that doesn't mean we have them in our homes or whatever. But when you go back to the history and characteristics of this defendant, and this is something that the defendant or counsel can't do anything about at this point, but this is a defendant who has over the last decade and a bit more managed to rack up 3 serious violent felony convictions, the most recent of which resulted in a significant term of imprisonment.
Has left the conference.
And this defendant was apparently on parole until 2018.
Has left the conference.
And relatively shortly after being discharged from parole, catches this new charge, which remains pending against him based on this incident in the diner. And of course, it is of great concern to the court that this defendant apparently continued to participate in the affairs of this Guerrilla Stone organization while out on bail.
A participant has joined the conference.
On the Manhattan diner incident case, and indeed the recent strip club incident involving Mr. Chrysler is another thing that's transpiring while the defendant is already out on bail. With regard to the fact that violence seems to be being perpetrated by associates of Mr. Senior, as is the case in the diner incident and also in the recent strip club incident. It is entirely plausible to interpret that as evidence of Mr. Senior's relatively advanced position in the organization. He doesn't have to get his hands dirty. He has people to do that for him. And looking again at the 2018 incident as well as the recent incident at the strip club, it is quite possible for the court to infer that people that cross Mr. Senior get hurt, although perhaps not by his hand personally. There is a statutory presumption of detention here on danger to the community grounds. Again, the court believes that statutory presumption is reinforced here by this defendant's prior established conviction record, as well as by these more recent incidents proffered by the government. So I find that the proposed bail package, formidable as it is addressed as financial packages often are, primarily to risk of flight considerations, and I find that the defendant has not rebutted the presumption with regard to danger to the community. So I'm going to order Mr. Senior detained on danger to the community grounds pending trial. With regard to the challenges that are posed by the pandemic to trial preparation and so forth, those challenges are real. All of us are challenged in the current environment, but in the face of a dangerousness to the community determination, I can't permit that to override the court's responsibility with regard to the safety of the community. We'll all have to muddle through and hope for that some of these challenges will abate in the coming months. So that's my ruling. Is there anything else from the government, Mr. Felton?
No, Your Honor. Thank you.
Mr. Kasouris?
Your Honor, there's one very brief issue that I just want to put on the record. We are unable to visit with Mr. Senior, and we do get some calls, but what I've done is I have set up a Securus line, but that is a line for which the calls are recorded. We have sent an email.
Left the conference.
We've sent an email to the company trying to explain to them that this is an attorney's number, it is a business call, and it should be privileged. So I just want to put on the record that, it's GTL.
A participant has left the conference.
That the government should consider any calls between myself and Mr. Senior, even though they're recorded, as being privileged until this company so designates. I have very limited contact with him, and I need to be speaking to him.
Mr. Felton?
Yes, Your Honor. The government certainly deems conversations between the defendant and his counsel as privileged.
I certainly think you do. It's just that they tell you when this call starts that it's being recorded and can be disseminated, and that's all.
And Your Honor, just one further thing for the record. We understand that video conferencing between the defendant and his counsel will resume on Monday at Westchester County Jail. It was temporarily halted due to a COVID quarantine issue, but now that's expected to complete after the 14 days on Monday, and they'll be able to video conference again.
Well, this is an ever-changing story, but as I indicated before, we all have to muddle through and get past these challenges, and I encourage counsel to work together to try to
has left the conference.
Meaningful attorney-client communications between Mr. Kasuris.
Brandon Belmonte.
All right, very well. Thank